About myself, I'm from Houston originally. I went to Baylor and graduated from South Texas College of Law. I've been in my current law practice about 8 years. I was licensed in 1990, but after practicing law for a few years and doing some other things, I took about 11 years off to help raise our children while they were young. So I just sent one to college and had a high school student. So that's kind of my background. So anyway, I'm so glad to be here. Y'all are a very sophisticated group, so I know that some of this is probably simplistic. Let me go back. I got to figure out how to work this. Okay. One of the main things I'm just going to go over the real basics of, why do I need a will and what are alternatives to a will, and then talk about powers of attorney and what those do and advance directives. I know that you guys look like a real sophisticated group, so you probably all have wills, but you'd be so surprised of the people that don't have wills, or that for some reason they have a feeling that that's such a horrible thing to go to a lawyer to prepare a will, so they put it off and they don't do it, or they have resentment about, oh gosh, I'm going to spend money trying to do something that's really important. So it's amazing how many people don't have wills, and I'll tell you some stories of people that didn't and what kind of problems it caused them. So we're going to talk about that, and then also what if you don't have a will, what are some other things you can do, and then talk about documents that I think everybody should have, which are powers of attorney. One of the benefits of a will, these should be obvious, but a will enables you to pass your estate to the people that you want it to go to. That sounds very basic, but you may have something else in mind other than what would happen if you passed away without a will. It helps you name a guardian. You can name a guardian for minor children. You can provide for grandchildren in trust. You can establish trust to protect your property. You can also provide for beneficiaries who have special needs. You can also choose who you want to choose to manage your property after you pass away. A will that has to be signed by the testator, that's the person signing the will. It has to be signed in the presence of 2 witnesses. Those witnesses have to be at least 14 years of age. The testator has to be 18 years of age and sound mind, and they need to sign in the presence of each other. And they need to have what's called testamentary capacity, assuming that they understand what their property is and that they have the capacity to understand what they're doing. And then the reason I put this about interlineations, it gets so interesting what you see when you're an attorney. I've had people bring wills to me that were signed at one time, but later they changed their mind about some things and just had scratch outs and initials and things like that. That might be obvious, but to some people that's not obvious. It has to all happen at the same time. So those interlineations wouldn't count. There are so many details about what can happen if you don't have a will, so we're not going to cover everything, but I just wanted to talk about a few problems that I see typically. If y'all would pass this around, it's a estate distribution chart. This shows, according to the Texas Estates Code, what would happen if you pass away without a will. How's your property distributed? If you don't have one in Texas, the law decides for you how your community property, which is property that you own jointly with your spouse, that you've acquired during marriage, and then it also has a separate distribution for separate property. And this is what would happen if you didn't have a will. First of all, if you're married, we look at the top of the chart. If you have separate property, which your separate property would be property that you owned before you were married, or that you inherited, or that was specifically gifted to you, that separate property will be split, between your children and your spouse with a life estate. Really what I want to talk about here is community property, because this is where I've recently seen many problems, because we have a lot of people, more and more often we have people that have been married more than once, that may have children from previous marriages, and not at all that uncommon anymore. If you are married to someone and they have children from a previous marriage and they pass away, their children will own their community, their portion of the community property. So does anybody see a problem with that? how that would practically play out. Y'all look at, okay, if you're married to somebody, you have a house that you own, that you purchased during your marriage, so it's 50-50 community. And say your wife, she passes away without a will, and she has children from a previous marriage. Her children own half of your house. They also have a claim to half of your retirement accounts. There's, you know, Texas law says that they do have a claim for half of the retirement, and there's a lot of lawyers that would help, that would be happy to see you to get half that retirement. Sometimes even if you have, you know, families that all get along with their stepchildren and all that, it can cause a problem. There are ways to fix some things, but this is something that you really can't fix. And so I always tell people, everybody needs a will, but especially if you are married and both of your spouses, you have children from other marriages, you need to do some very careful estate planning to make sure, number one, your estate goes where you want it, but secondly, that you know, you avoid conflicts in your own family after you pass away. Anyway, here's the rest of the chart. It's self-explanatory that you can look through, but I think this is just helpful just to see, you know, how your estate would be split if, you know, if you were to pass away without a will. This is one of the things that I just mentioned about that I see quite a bit. Also, I've had situations or seen situations where someone may not really understand what community property is. If you buy a house before you were married, it's your house, it's separate, but any income or increase in value after you were married becomes community. Income that someone earns during marriage is community, so whether it's earned by the man or the woman, it's community property. People don't understand that. And so I've heard of a number of situations where someone may think, well, you know, my spouse hasn't earned any money, so they don't really need a will. And that's a common misunderstanding about that. So in Texas, we have things set up to protect spouses. Some other things, I just had mentioned problems with the retirement accounts. You also want to take care of inheritance of minor children. If someone passed away unexpectedly and had young children, they would have to have a guardianship or some other type of legal vehicle to take care of those kids. I've been to a seminar and heard people say, look, if you don't own a house, you don't have certain types of property, you don't need a will. To be honest, I would never advise anybody, never say that, because I've been to the courthouse 100 times where there's someone down there doing an heirship to be able to claim one account that their family member had that they didn't name a beneficiary on the account. And the only way to get that money is to get a letters testamentary, to go down to the court and probate the will. And here it's a very small estate, and they're spending quite a bit of money to do an heirship. And so I think it hurts really small estates the most. Many times, of course, you can have unintended beneficiaries, as you can see. It also, dying without a will, it doesn't address issues of charitable giving or anything like that. You're just leaving all that out. I know y'all are looking at me like certainly everybody has a will, but you'd be surprised how many people don't. So when in doing a will, if you have a very simple estate, a simple will is leaving your estate to your beneficiaries directly without any kind of trust. You always want to have what's called a contingent trust, and I just see a contingent trust, which is for minors or anybody under a certain age if they become a beneficiary. What I typically do with a will is to provide testamentary trusts. These are trusts that are created in the will, and they're funded at the time the person dies. And so I think this is the simplest way to do estate planning, the least complicated, because you're not trying to fund a trust. What do you mean by that is transferring the property to a trust right now. This is going to be based on what do you own when you pass away. And sometimes, you know, people who are quite wealthy, by the time they pass away, they may have spent their money on medical care, living, or things like that, and it's just most practical to have a will rather than another type of trust vehicle. A testamentary trust, it just roughly, it protects assets for children if your one spouse dies and another spouse remarries. It also holds funds. You can use a testimony trust to hold funds for minors or for young adults, just so they won't spend their money right away. I mean, I think I have a 18-year-old who's a great guy, really responsible, but I wouldn't want to give him a lot of money just because he's 18. You know, there's nothing wrong with him. So you may have young adults who may even be irresponsible, or it may just be because of their age. Also, there's benefits that can be tax benefits to a testamentary trust. Also, if you have any family members, beneficiaries who have special needs, who may be receiving government benefits, you know, or they're being disabled, many of those benefits are means tested, which means if that person inherited from you directly, either through intestacy or through a will, they would lose their benefits. It could actually hurt them. So that's something to take into account. Your beneficiaries of a testamentary trust are also protected in the event of a divorce. For example, if I leave my estate after my husband dies to my children in a trust, if one of them were to get a divorce, it would be nearly impossible for their spouse to claim property that was held by that trust. This is sort of a very basic chart, but I always say, here's the husband and wife, H and W. You each own your 50% of the community plus your portion of separate property if you have it. I always pick on the husband first and say the husband dies first. Let's say his estate, instead of going directly to the wife, will go to what we call a bypass trust. It's also called a family trust. And it would be held for the surviving spouse for their health, education, maintenance, and support, which basically they could use that account for many things. They would transfer their assets to that, or their 50% of the assets. And this is something that's determined at the time of death based on what they own, what their assets are with the funding agreement. And that lasts for their lifetime. When the wife passes away, it goes to the beneficiaries, which would be usually the children or descendants. There's many different variations that you can do to say if you go to the beneficiaries or descendants for their lifetime, and then to grandchildren, you can have a generation skipping trust. There's a lot of variations there, but this is the basic just model. A marital trust would be the trust that would be created if you had a larger estate than what the current federal estate tax exemption is when you pass away. And then it's a separate trust that goes to the beneficiaries after the second spouse dies. I draw this chart just to tell you the problems that we see in estate planning. If anybody has, I'd say, young children, they have maybe not a taxable estate, but a fairly large estate, I generally like to use this model for the fact that it protects the children. It gives them just a way to hold funds for them for a long time if the parents have a premature death, and if the spouse remarries. For example, let's say we don't do this. Let's say husband dies and leaves everything to his wife directly. If she remarries, then she starts to commingle that property with her new husband, and it's confusing over what's community, what's separate, we're not sure. And let's say when she remarries without a trust, she dies before her second husband. Who is going to end up with most of the property is going to be the second husband's children. Okay? So this kind of controls the property beyond the death of the second person. Does that make sense? Feel free to interrupt me. There's many just issues in probate in general where, and sometimes it's intentional, there's bad people out there, but sometimes it's unintentional, where there's second marriages, there's children from different kids, their estate planning isn't done properly, and then who knows who's going to end up with what. Sometimes people think, well, it doesn't matter, I'll let them work it out, but that costs a lot of money to work it out sometimes. Then also sometimes you have maybe something that's special like a family farm or other property that you want to keep in your family, and that's a way to do it. Did you have a question?
Yeah, since the estate tax exemption is portable now, has that changed the way people think about funding their bypass trusts?
Yes. Do y'all know what he means by that? I have something on that. Yes, it can. It does change it to a certain extent, but right now, basically, I'll answer your question just by explaining the federal estate tax exemption right now is fairly high. It's $5.34 million a person, or $10.67 million. It used to be that in order to claim your spouse's exemption, to have the benefit of that as well, you would have to have a bypass trust. Now there's a way with an estate tax return to claim that exemption, and so it's not, you don't have to have a bypass trust anymore. I feel like that the benefits of the bypass trust are primarily to take care of kids and beneficiaries. It's not only for estate tax. The other problem that we see to take advantage of what's the portability and to claim that, the executor of your will or surviving spouse would have to file an estate tax return after the decedent, after the person who passed away. They have to file that within 9 months to claim that portability. And a lot of people don't know that, and so it's lost after that. And so using the bypass trust is a way to make sure that's intact, even if you tell somebody they need to do that. The reality is, by the time somebody passes away, they'll forget that. The other thing is that a bypass trust, a bypass trust includes the increase in value. So for example, right now, you can fund into a bypass trust up to $5.34 million. If you're right on the cusp of having that much money, by the time the second spouse dies, probably there's going to be more than that in that trust. And so when you use the bypass trust, it includes that increase, and that would pass estate tax free when the second spouse dies. But when you use just portability without the bypass trust, it would not include the increase. So it does change it somewhat, but really as an attorney, what I do is advise people on protecting the assets for their family. Estate tax has something to do with this, but not 100%. Does that make sense? Okay, I don't really know how to go like that.
Actually, yeah, Ashley comes out. I don't either.
So I don't know how to go back.
Everybody's.
Did that answer your question?
Everybody's stuff is different.
You know, one thing I was just going to explain briefly, and certainly, I don't know, do y'all already know all this? I don't know if y'all do or not. I don't know, but because Carl said, keep it simple, so I don't know if y'all already are familiar with all this. The bypass trust holds the amount up to the federal estate tax exemption. So right now, because our exemption is fairly high, you know, not as many people have marital trusts, but typically what I do is I'll prepare, if somebody's even close, I prepare a will with a bypass trust and a marital trust. And what will happen is when the time comes when they pass away, if they don't have a large enough estate to fund a marital trust, it just is irrelevant. It doesn't matter. You can't go back in and add it later. So what the marital trust does, it just gives additional, for larger estates, additional control of that property to the next generation. Does that make sense? Okay. This is basically, I've already kind of explained this, but it can be used to assure the use of the tax exemption if somebody did not know to file an estate tax return. And when the first spouse dies, that trust is funded. That amount of whatever is in that trust is not subject to any estate tax, regardless of how large your estate is. It would just happen on the death of the second spouse to die, but whatever is in the bypass trust would bypass the estate of the first spouse, or I'm sorry, the surviving spouse. So, okay. The other thing is the marital trust, which I've already explained. This is also, you may have heard the term Q-tip trust, if you've heard that. It's a qualified terminable interest property trust. This is designed to hold the amount of the estate, which is over the federal estate tax exemption. One thing, just to clarify, there's something called an unlimited marital deduction. So regardless of how wealthy someone is, what their assets are, you can leave an unlimited amount of property to your spouse. The federal estate tax is just applied at the time of the second person to pass away. This is kind of, when I answered your question roughly, the bypass trust will help avoid pitfalls of not knowing how to claim the portability exemption, even though you can do it. Some people don't know that. So it also includes the appreciation of assets, which we already discussed. Okay. Does anybody have a question about anything? Many times I have people come in my office and they say, I've been to this seminar and I've heard that I need to have a living revocable trust because I'm going to put everything that I own in a trust and I'm going to avoid probate because probate is horrible. It's just the worst thing, and I'm going to have everything in a trust and avoid probate. And sometimes that's a good idea, but I hear that so many times, and what I'm convinced is that somebody's made a lot of money giving these seminars, but I don't know. I mean, people with not even big estates will come in with a huge binder of all this stuff. I'm thinking, what in the world is this? And they've been to one of those seminars. Sometimes a living revocable trust is the right thing to do, but sometimes not. So we're going to talk about that. This is a trust that, unlike the testamentary trust that's in your will, it's created in your will and it's funded at the time you pass away based on what property you own. This trust is funded right now. It's more of a management tool. You create this trust during your lifetime and you transfer all your property to it. One of the benefits is that it provides for someone who becomes incapacitated. You can name an alternate trustee to manage your affairs during your lifetime. The other thing is that basically it provides the same provisions that a will would provide. When you pass away, your trust would become irrevocable and could have the same language in it that would be for the bypass trust, the marital trust. If you're a married person, it would provide who would receive your property. So it's not, not necessarily a bad thing to do. I've kind of put here pros and cons. People get a living revocable trust thinking, well, I'm doing this because I'm going to avoid going down to the courthouse and doing a probate. The reality is a huge amount of people who have trusts also do a probate because in order for it to work properly, you need to have every asset that you own, every bank account, your cars, maybe not your cars, I can tell you about cars, but your real estate, stock, everything has to be held in the trust. If there's something that is not in the trust when you die, you will have to go probate a will. So typically what we do is create what's called a pour-over will, which leaves everything to the trust. And if you've done a good job and managed your trust, you will not have to probate that will, but just as a backup, we always do the pour-over will. And so that's why I say it may avoid probate. A living revocable trust is more cost at the outset because you need to transfer all your assets to the trust right now. So you may need to pay attorneys to do deeds of property, to deed property to the trust. You'll need to change all your accounts over. You'll spend time talking to your financial advisor or other bankers, getting everything transferred over. So it's more work now. The other thing is that a living revocable trust requires continued management. Anytime you open an account, buy anything that has a title, you have to make sure it's in the trust. You can have the benefit, I think, is to have an alternate trustee to manage your property as you go older. Also, people that have vacation homes, out-of-state property, I think a living revocable trust is a good tool because you don't want them to have to go to Colorado to probate a will to pass title to their vacation home. So that's one time when I do suggest it. I also suggest a living revocable trust for fighting families. And what I mean by this is, really you can have all this will, but after you pass away, people can kind of do what they want. And if they'll figure it out. If you think that your children or heirs are untrustworthy, or you think that there's a lot of conflict among them, and particularly if you have a larger estate, sometimes a revocable trust is a good tool because you transfer everything now and you're managing it during your lifetime. The benefits of really having a will, which is what I use most of the time, is that it passes the assets you own when you die. So I've seen many times that people have a trust, they've spent all this money transferring everything to the trust, but the reality is by the time they pass away, they've depleted most of their assets, they've spent them on medical expenses, or they've already gifted a lot of money to their children. They really have a much simpler estate by the time they pass away, and you could have just not spent all that money and management and time doing it. So it's, it's just kind of a judgment call. If you have a will, there's no maintenance during your lifetime. You know, it's just all dealt with at the time you pass away. And those trusts are funded, if you have testamentary trusts, are funded when you die. Does anybody have a question on that? One thing that I hear people say, they say, I want a revocable trust because I want to have asset protection. This kind of trust does not give asset protection because you can revoke that trust now. It is, you know, a creditor could still claim something that was in that trust. The only way to receive asset protection is to have a third-party trust, which when you pass away, these trusts to the beneficiaries become a third-party trust because it was created by another person, or to have the trust irrevocable with a third-party trustee. And I just mentioned that because, you know, people say that kind of thing quite a bit. In Texas, estate administration is honestly very easy. It's really easy to probate a will. A will should be probated within 4 years. When I say probate, what you're doing is filing it at the courthouse, going down and putting testimony in the court record that authenticates the will to prove it up, and making it part of the court record so that your creditors, if you have any, can look at your will. If there's a question about real property, whenever property is sold, the title company looks at the probate records. You're putting it in the record. It's very easy. People, there are times when you think, okay, I want to avoid probate, but honestly, the bad probates that you hear about are the people that are fighting with each other, their kids don't get along, they're suing each other. That's when probate's bad. If everybody gets along and you go down to the courthouse, and probate a will, it's not a big deal.
You know, one thing that people don't realize is Texas has independent administration, where if you put in your will that you want it to be administered independently, then you have one hearing, you file your application, you have one hearing. I think all the other 49 states don't have that, so every time the executor wants to dispose of property or sell anything or do anything, they have to go to court and have a hearing. And so that's a big part of the reason why probate is perceived as very expensive. But in Texas, that's not necessarily the case because it's just a boilerplate clause that I'm sure you're very familiar with.
But in your will, we say there was no other, nothing required other than probating the will and filing an inventory or present list of claims. It's very easy. We do have dependent administrations, but usually that'll be if there's a conflict in the family or something like that, they can ask for it to be dependent or court supervised. Most of our administrations are independent, and it's very easy and simple. A lot of people have thought, well, I don't want to do probate because you have to file an inventory, and for privacy concerns, I don't want people to know what assets I own. I don't want that down there at the courthouse for anybody to see. A few years ago, there was a new law where you can file an affidavit in lieu of inventory, where you state that all the beneficiaries have been notified of what the assets are, and they've been given a copy of the will, a copy of the list of assets, and the executor can file this affidavit, and that'll be the only thing on file. One of the things that's important to talk about is non-probate assets. A lot of the property that we own are not what we call probate assets. A probate asset will pass under the provisions of someone's will, or by Texas law, as we discussed, if they didn't have a will. A non-probate asset passes according to either a beneficiary designation or a contract. And those would be things like life insurance policies, where you name a beneficiary, retirement plans. You can have payable and death bank accounts, or accounts where you have a joint tenant with a right of survivorship, where say you share an account with someone, and when that one of the joint tenants passes away, the ownership goes to the surviving tenant, their joint tenants. It's very important to coordinate these accounts with your estate plan, because if not, you can have unintended consequences.